rise. The Court of Appeals, Division 1 is now in session.
Good morning. You may be seated. We are here on our case number 1CACV150862, Romero versus STEINKE et al. Both of you know that you're allotted 20 minutes aside for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. The clock on the podium reflects the total amount you have remaining, including what you may have decided to reserve. We record the proceedings, so we'd be grateful to you if you would, when you approach the podium, recite your name for the recording. We have read the briefs, and we've looked at the record on summary judgment extensively. We've also discussed the case in our conference. So with that, Mr. Bam, you may proceed.
Good morning, Your Honors, and may it please the Court. Judge Bean, I don't believe we've met. My name is Scott Bame.
You don't remember State versus Stummer and State versus Lum that we did together?
I'm
a little taken aback. So
I have done only a couple of criminal cases, and that was a sex regulation case,
yes,
if I remember right. So my humble apologies, sir.
It's the beard and the glasses.
I'd say you were younger then, but I don't want to get even deeper into trouble. Anyway, we're here today on a med-mal case. Plaintiff's theory of the underlying trial is that the plaintiff, Ida Romero, had an unsterilized crosslink put into her spine during spinal surgery by Dr. Steinke, which led to permanent paralysis. There's no dispute that we have evidence to support breach of the standard of care, and causation is the only issue before the court. And it's a pretty straightforward issue, I think. Was it error to grant summary judgment for these defendants for insufficient causation evidence from our causation guy, Dr. Larry Rumens, who is the director of infectious diseases at Oro Valley Hospital in Tucson. One of the things that I think is important to keep in mind is this is a summary judgment. The trial judge did not exclude or deem Dr. Rumens' testimony inadmissible. Defendants raised that, I think, maybe I'm cynical, as a method to try to get an abuse of discretion standard of review, but I've read that minute entry time and time and time again, and basically nothing was mentioned about admissibility, and the only question was whether what Dr. Rumens said was sufficient to get to the jury on causation. And
can I interrupt you and go back to something you said at the outset, which is just sticking in my mind? You said your theory is that Ms. Romero had an unsterile device implanted. Is that what you mean is your theory, an unsterile device? Or do you mean contaminated device?
Contaminated, yes, exactly.
Well, those are different, I think.
Well, here's the facts in this, and I'll point.
I know the facts.
And I don't mean to badmouth the trial judge on this because.
But what is your theory? That it was an unsterile device, or that it was a contaminated
It was
device?
contaminated and not sterilized after it got to the hospital. As and I'll tell you some of the facts. I'm sure you know that, so tell me to shut up if I get into detail here. When they went to put this crosslink in, when they decided to put it in, they didn't have one at Estrella, so it got hauled over in some guy's car from Boswell. And when it got there, and there's the evidence, and the trial judge got this wrong in his minute entry. The evidence is from Nanette Ford, who's the Boswell sterilization lady. They cannot confirm that this particular crosslink, or any particular crosslink, was sterilized at Boswell, let alone once it got to Estrella. And it's undisputed that when it got to Estrella, contrary to policy and procedure and standard of care, it was not sterilized once it got there. Instead, David Bettis, who worked for Medtronic, met the dude in the hall,
That's-
opened it with his bare hands.
That's a cool part of the story, and I want to interrupt you before you get to the cool
Okay.
part of the story. The boring part of the story, isn't there evidence at Boswell that there was a crosslink that was sterilized the day before? There's just not evidence using barcodes or whatever that it's that one?
Yes, yes.
Okay. And there was evidence that when the guy took a crosslink over to Estrella, or I forget,
Yeah, you're right, you're right.
that it was wrapped in the kind of paper that you would wrap it in if it were sterilized, and that it had the black bands on it.
Right.
Okay.
And that's the real problem here. is
Okay.
Once it gets there, Bettis goes out in the hallway. And this is the evidence. I'm going to just kind of tell you first person here, but it's the evidence, not Scott Bain. Bettis goes out in the hallway, meets the guy who brought it over, takes it directly into the OR, and he's not scrubbed, he's not gowned, doesn't have gloves on, tears it open with his bare hands, and according to his testimony, touched this, whether it was sterilized at Boswell or not, touched it 1 to 2 times with his bare hands, puts it on what they call a Mayo stand. I don't know what a Mayo stand is, but it's undisputed that the Mayo stand is unsterilized.
So he says, I touched the crosslink with my bare hands?
1 to 2 times, he said. I discussed that in the brief with the specific citation to his testimony. So that's the real problem, and that's where I think, I'm kind of reading into where the trial court might have got this wrong, because in my own mind, and granted I'm biased, this doesn't even seem like a close question for me. But the trial court, in his, I don't even know if it was a him, in his or her minute entry, which is in the record, ROA 326, says that, and this is one of the 2 main reasons he granted the summary judgment, is the plaintiff was not prepared to offer evidence to verify that the crosslink was contaminated. That's just not true for everything we've been talking about here. And then he goes on to say, there's no evidence of an event that would obviously have contaminated the device, that it was dropped on the floor or wiped off on someone's shirt. Well, no, but he touched it with his bare hands and put it on an unsterilized stand. It was probably, your hands are dirtier than your shirt. I took this out of the dry cleaner.
Have you got a record site for that testimony, or could your
Sure, it's all in the
finding
brief.
it in the meantime?
And I was kind of
Okay.
anal in the brief, as I always am.
Okay.
It's on, I discussed this evidence at pages, I think, 13 to 20,
Okay.
which was the...
Mr. Payne, didn't Mr. Rumens admit that there was no direct evidence that the protocol violations caused the crosslink to be non-sterile or contaminated? Didn't Mr. Rumens or Dr. Rumens say that?
What Ruman said is we don't have any direct evidence that it was, in fact, contaminated. But he went on to say that because of this kind of horrific procedure of opening, and Bettis got canned and thrown out of banner, and this was a big problem. When the nurse, the OR nurse, found out that the plaintiff had to come back with an infection, she wrote up this whole thing, and that's, and I quote her report too.
But getting back to what Judge Bean asked, didn't Dr. Rumens also say that the overwhelming majority of spinal epidural abscesses are not caused by contaminated
No,
instruments?
I think he said just the opposite of that. It's the overwhelming majority are caused by that, and that gets into the
correct.
differential diagnosis.
Let's assume he said what I just said, because...
Well, if he said the overwhelming are not, that just kind of goes into the mix with the jury, because he explained in detail why this one was. And again, it gets back to Bettis. I mean, he's the guy that really screwed up here and was handling this with bare, unwashed hands. And I got panned in the answering brief for calling a spade, I guess, but that's what he did. He opened it up and he said he handled it 1 to 2 times and put it on an unsterile tray, after which, and then the nurse said she saw it over there, called attention to it, and when she wrote up her report. So that, in our theory, is where the contamination occurred. If it was ever sterilized, it certainly shouldn't have been handled by the sales guy with his bare hands and then stuck in our poor client's back. So the trial, I guess my point on all that is that the trial court's facts recitation is just wrong based upon what actually happened. He says, and then I'll shut up on this point and move on to another one. He says, it appears that the device was properly sterilized and wrapped at Banner. Again, as Judge Downey pointed out, Banner can't, or at Boswell, he says Banner, but Boswell can't confirm that. And then once it gets there, the whole process falls apart. In the trial court, and this was Medtronic's motion, principally, they settled out. Dr. Steinke and his former employer joined in. So in the trial court, they argued Dalbert stuff, that there was no foundation for this, that our guy didn't state it to a sufficient certainty. So I addressed all that stuff in my brief. None of that's at issue any longer. They've made it very clear in their answering brief, and I talk about this in the reply, very clear in the answering brief that the only issue now is that Dr. Rumens did not do a differential diagnosis on either was it an infection, and if it was an infection, was it the cross-link, what caused the infection. We've already talked about the second of those, why he homed in on the cross-link, because, and you know, I've probably read this 10 times in their brief, there's other things that can cause these. He very clearly said in response to, I think it was Mr. Cummings taking the depot, he originally gave his declaration of opinions. They were expanded upon during cross-examination at his depot. And then after their guy, Katana, hammered away at his depot opinions, our expert gave a supplemental affidavit. It was at his deposition that, in response to either Mr. Cummings or whatever lawyer was there for defendants, asked him, what about all these other potential causes? And he said, well, yeah, there's other possible reasons, but she didn't have any of them. And that's essentially what differential diagnosis means. When you, so she didn't have this, she didn't have that, she wasn't a drug user, she didn't have valley fever, she didn't have any other post-operative problems that could have caused this infection. She didn't come into the surgery with any kind of an infection. When everything else is thrown out, the cross-link is what's left, especially when it's the most glaring potential cause, because Bettis was handling it with his bare hands.
That's assuming she had an infection.
Yes, well, that's the other question, and that's what I'm getting to, and this is something that they bring up too, and where the trial judge again got it wrong. Get to my notes on that issue. In explaining why it was an infection, he again said there was no other cause of that, but in addition to that, there was this copious drainage, there was pus, there was increasing, spiking pain, pain that was increasing, spiking fever. There were white blood cells in the blood tests, and some of the gram stains were positive. All of those indicate an infection. Now, the trial judge, and again, with de novo review, you don't really have to care what the trial judge says, but another place that I think he or she got derailed said that that Dr. Rumens didn't accurately address or didn't appropriately deal with. Dr. Rumens never comes to grips with the possibility of a non-infectious etiology. Well, of course he did. All of those things I just talked about. This could have been a non-infectious thing, but it wasn't a non-infectious, because if it wasn't an infection, she wouldn't have had pus. Wasn't an infection, she wouldn't have had white blood cells. If it wasn't an infection, she wouldn't have had a fever. If it wasn't an infection, she wouldn't have the copious drainage. He explained all those things. Now, the jury may not believe it. Go ahead, I'm talking over you here.
Now, I was just going to say, at some point, the expert needs to cite facts that would support the conclusion. And that's what makes this case interesting, I think, kind of the intersection of 702 and 56. But it's not enough for the expert, is it, to say she had increased pain, must have been an infection, when there's another equally plausible, in the abstract at least, explanation for the pain?
I don't think there is another equally abstract explanation for the pain. They're only what they get back to again and again and again. And after you get rid of this, and especially when you look at the 7 factors that Dr. Rumens relied on, lack of white blood cells, lack of fever, lack of pus, lack of pain, lack of wound drainage, all those are false. I mean, that's what our guy said in his response. I mean, I'm no trial lawyer, but I could cross-examine this guy because everything he said is false. Contrary to our theory, what they, to finally answer your question, what they rely on almost exclusively is the negative culture results. And that's what caused, in addition to being sued in the paralysis and banner opening investigation, that's what caused Dr. Steinke to 6 weeks later go back and change his report and said, well, I guess even though I thought it was, I and everyone else thought it was a epidural abscess infection, it must not have been because of the negative culture results. Well, as Rumens and Simons and Dandavant, all explained in their depositions, this woman has been on heavy doses of antibiotics for a week. The whole purpose of these antibiotics is to suppress growth of the virus or the infection. So that explains them, and they can argue to the jury till the cows come home that that's the dispositive factor. But if they're explained away, what if the jury buys our theory and it's supported by the hospitalist at Banner and the infectious disease specialist who's brought in? This is why we have trials. And if they get if there's an explanation for why these cultures came back negative, that destroys their whole theory, because that's pretty much everything that they rely upon. I'm down to 3 minutes.
Okay.
If you don't mind, I'm going to hang on to it.
Thank you. Thank you.
Thank you very much. I'm Fred Cummings, and I represent Dr. Brian Steinke as well as Arizona Spine Care in this appeal today. I was also the attorney who represented these parties at the trial court below. The issue in front of you is whether the trial court abused its discretion in properly applying Rule 702, Arizona Rules of Evidence, in evaluating the expert testimony of plaintiff's expert Larry Rumens. You know from reading our brief what we think about that, don't you? But let's talk about this from a broader context. So we know that in the last 10 to 20 years, our state, our legislature, has given special scrutiny to medical negligence cases and the proof that is required to present those cases. There's a statute that requires experts to have a certain amount of expertise, as well as what we now have is increased scrutiny of experts under Rule 702. And you've seen some of the cases do that very thing since we've adopted the Daubert standard several years ago. So this is a proper case to evaluate whether the expert should be allowed to testify at trial. This is the proper gatekeeping function of this judge. The trial judge weighed 2 independent issues very carefully and concluded the plaintiff's expert fails on both counts. First, to be able to prevail on an issue of causation, the plaintiff had to show that the plaintiff received an infected or contaminated crosslink. Number one. Then, assuming that there's proof of that, they have to show that it, in fact, seeded an infection that led to a spinal epidural abscess. The trial court concludes on both grounds that the plaintiff failed their case, and we think that the overwhelming amount of evidence, as well as the case law on this issue, supports the trial court's decision not to find the opinion reliable under Rule 702. Let's talk about the crosslink issue.
I'm particularly interested, I think we're particularly interested in knowing about the bare hands testimony.
Yeah, and I appreciate that, Judge. Let me, and I don't want to talk about that because really two things. One is, was this sterilized? And two, was it contaminated after the sterilization procedure? Really, those are the two issues as to the crosslink, aren't they? First of all, on the sterilization issue, really there's undisputed testimony that it was properly sterilized at Banner, Australia.
And do we know this because it was found in the sterile core?
That is correct. That Josh Kalapong as well as David Bettis both testified that typically, and it was Kalapong that retrieved it from the sterile core at the transferring hospital, and took out the tray just as he would any other tray for preparing for an instrumentation for surgery such as this. The testimony is undisputed that the custom and practice and the protocols in terms of the handling of that tray were followed, with the one exception that it didn't go through another sterilization procedure at Banner, Australia. And so there isn't any evidence that it wasn't sterilized because the evidence is that it was taken from the sterile core, that it was then in its double-bagged presentation, it was wrapped twice, and that it was then taken from there to the hospital, presented to Mr. Bettis. Mr. Bettis takes it as any other equipment representative does in preparing a tray. And his testimony was pretty clear about that. Now, as to your point, Judge, because they make a big deal about the fact that Mr. Bettis testified that he handled it with his bare hands. Let me suggest to you that that is not the testimony. Now, the quote was in the reply brief, and it's found at page 9 of the appellant's reply brief. But it stops curiously short of the rest of the testimony and tries to basically extrapolate that when Mr. Bettis said, well, you touch it one or two times, that he was talking about the crosslink. But I urge the court to actually look at, one, page 11 of our response brief, but also the actual evidence that we cite in our response, which quotes the very testimony that Mr. Bettis testified, and you'll see that at page 11 of our response. It's page 149 to Mr. Bettis's deposition testimony. And Mr. Bettis goes on and explains, after the quote that was found in the reply brief, Mr. Bettis goes on and explains that what he was talking about was the wrapping on the tray, and that you might touch the wrapping one or two times, but he makes great pains to say that the non-sterile part never touches the crosslink, and that's all found at pages 149, 150, and 151 of the deposition testimony, which was attached as an exhibit to our brief. So there is no evidence that he, quote, contaminated.
So what you're reading that testimony to me, if I can interrupt, is that when he pulled the tab on the sterile wrap and it poof opened like a present, that was what he was talking about, that he touched the tab and the wrap, but not. You read the testimony to say he's not touching the device itself.
And I can read the testimony here if the court prefers, but
we can.
But I think it's pretty clear what he's talking about in terms of the testimony. I mean, it goes on for over a page as to what his custom and practice was, and that it was no different than what they would normally do in setting up a surgery. The only difference here was that it didn't go through that second sterilization procedure. Mind you, second sterilization procedure at the operating room hospital, as they said. So to get to Dr. Ruman's opinions, that this was an infection, you have to predicate it that the crosslink itself was contaminated. Not just that whether it was sterilized properly, but it was contaminated. And there was no evidence presented below that there was any contamination of the actual crosslink. And that was what the trial court correctly relied upon. So, because the evidence was that this crosslink was handled just like every other instrument on any tray. And it's even more important that if in fact there was this evidence that Mr. Bettis handled the crosslink with his bare hands, don't you think Dr. Rumens would have been all over that? Instead, Dr. Rumens' testimony is pretty clear. There was no direct evidence of contamination. There's no evidence that it was in any way, seeded with an infection even after it was removed. After this crosslink was removed, it was sent back down to pathology, and the evidence below, and that's in the record that's in front of you, is that it was tested for a biofilm to see if there was any type of dead soldiers, the bacteria that supposedly the antibiotics would have killed, and this came back clean. Also noteworthy, and it's also in the record in front of you, that the patient continued to have symptoms, the inflammatory response, after the crosslink was removed. So there's no direct or real circumstantial evidence to show this crosslink was either not sterile or contaminated. So you can stop right there, because what they're trying to do is wrap what Dr. Rumen's standard of care opinion is if the doctor should have known that it might have been mishandled, I presume it's contaminated, and he shouldn't have proceeded. That's a standard of care opinion. That's not a causation opinion. As to whether or not the doctor even knew, that's not in front of you, although I'll tell you that the testimony from Dr. Steinke was that he didn't know. But number two is it has nothing to do with whether the actual crosslink was contaminated or not. As to whether or not, the presumption of contamination is not the proper subject for presenting your case to a reasonable degree of medical probability. Instead, he tries to shift the burden to the defense to show that the crosslink was in fact sterile. And even though that's not our burden, we've pretty much met that with the testimony and the protocols.
Well, let's talk about whether there was an infection or not. What about Mr. Bain points to elevated white cells and positive gram stains.
All right, so
what about that evidence?
let's talk about that, because that is the second prong. Can they even show from any really degree that there was actually an infection? Because in the record in front of you, there is no evidence that this was actually an infected area of this patient's body. None whatsoever.
Well, can you clarify whether I'm right or Mr. Bame's right about what Dr. Rumen said about the overwhelming majority of spinal epidural abscesses are caused by or are not caused by contaminated instruments?
I did not find that in the record, that the overwhelming majority of spinal epidural abscesses are caused by contaminated instruments.
Well, in your answering brief, you say Dr. Rumen's admitted that the, quote, overwhelming majority of spinal epidural abscesses following spinal surgery are not caused by contaminated instruments. Mr. Bame said it was the opposite.
Right, and I don't know where.
Look at that record site.
I don't know where that is obtained in the record.
Well, you cite it here. I'll look at it.
And there was literature that was cited below and relied upon by the trial court judge that would indicate the exact opposite, that when you have a spinal epidural abscess, you would expect to see positive cultures. You would expect to see positive gram stains or positive or indications that there were antibiotics that did their job.
Dead soldiers.
Dead soldiers, so to speak, exactly right. So, but really what the trial judge was doing in this case, in looking at the issue of infection, was not trying to conclude whether Dr. Rumens was right or wrong, but rather looked at the methodology of this expert as to whether or not, by incanting the magic words, reasonable degree of medical certainty, that somehow that confers the imprimatur that there is an infection here, and we submit it doesn't. First of all, so we don't have any basis to show that if there was an infection, it was somehow traceable to this crosslink device. That's number one. But number two, the trial judge looks at this and he says, look, the methodology is flawed. If you look under Rule 702, what you really have to look at is what does the expert articulate a reasonable basis that this is either an accepted conclusion based on medical literature, or that by application of experience and methodology, that the methodology is sound, or 3, the expert's own knowledge in terms of his training experience. And the trial judge pretty much determined that it failed on all 3 counts, that the methodology of this expert was flawed. First, sterile seromas, which is what the concluding diagnosis was for this patient, are way more common than spinal epidural abscesses, and that was actually cited and quoted in the record in front of you. In fact, that's undisputed. Plaintiff doesn't really ever dispute that. Appellants don't dispute that. Second, though, is then when you say that, okay, so I know that there was an infection, the trial judge looked at the methodology as to how Dr. Rumens came to that conclusion, and used it actually, and used the contrast of the defense experts to show how the methodology was pretty much non-existent. And that's where you go into the differential diagnosis analysis that Judge Hanna employed, in that if you look at what the experts rely on typically in this field, they look at objective analysis. That is, what do the clinical studies find? They find lab studies, cultures, Gram stains. They rely on that for diagnosing infection. And those are very specific findings. What Dr. Rumens tells you is, yeah, but there is evidence of infection. Here it is. She had a fever. She had a lot of drainage from this wound. She had pain. The problem with Dr. Rumens' analysis there is those are what are termed non-specific findings. There can be a number of explanations for those, including a sterile seroma, because a sterile seroma can produce the type of reaction in the body that can create more fluid. In fact, that's what it is, and that's what created the impingement or compression of the nerve that led to her paralysis. The fact that she had major back surgery with instrumentation would explain the pain, but even if you put that aside and say, but also in addition, she had this inflammatory process going on that put pressure on her spinal cord that could cause pain as well. But again, not exclusive to infections. It's exclusive to basically to a sterile process going on within the cerebral spinal fluid of this patient. So that's number 2.
What about, Mr. Bain points to the specific findings of, he says white cells were elevated and that there were positive Gram stains. Does the evidence support those assertions? No.
The elevated white blood cell counts, what Dr. Rumens says is there were findings of elevated white blood cell counts from time to time during this operation. And he says, but the fact that you have elevated white blood cell count in and of itself doesn't indicate that there's an infection. Again, there are many other causes for elevated white blood cell count, including just the fact that the patient's in pain. That can normally just elevate your white blood cell. It's a non-specific finding for that reason. So when he looks at the methodology, did he properly exclude other causes? Well, he didn't exclude the sterile seroma cause. But then, even if you assume that this was an infection, he doesn't exclude by methodology the 10 other possible causes that could have seeded an infection in this patient. Whether it was a skin surface infection, which frankly are usually how most infections postoperatively are seeded, or whether it was from the epidural that was done during the surgery itself, or whether there was an infection in some other place in the body, or whether the patient sustained a trauma, which, by the way, this patient did. This patient did fall in the hospital.
What was the context of his foot beats from Africa comment?
I think I'm not exactly sure I know what the context was, other than it's like, well, if it looks like an infection and smells like an infection, maybe it's an infection. And I think they rely mostly on the fact that to the practitioners at the time, for example, you'll see some discussion as to, well, it looked like pus. Now, there is not an infectious disease expert in the world that diagnoses an infection by how something looks. But that was what they're relying on. But I think when they're saying, don't look for zebras when the horses are in front of you, I think it's all of these other things, the non-specific findings that they're relying on. So I want to talk also briefly about the fact that, in addition to the methodology being flawed, there was no medical literature that supported this or an explanation as to why the literature that goes the other way doesn't apply. And that's very important because there was a body of literature that was quoted and relied upon by the defense experts and quoted by the trial judge that the plaintiffs were silent on as to why. How come this is the exception to the rule for spinal epidural abscesses, which are typically diagnosed by gram stains and blood cultures? No such experience. You also want to focus a little bit on this issue of, well, but we should give deference to experts because of their experience. Now, first of all, let me submit to you that it's true that in medical malpractice trials, we do give a lot of deference to a physician's experience, although we do hone in on that specific experience. In fact, the statutes require that a standard of care expert, for example, has to have specific experience to what is being at issue. And that's in the statutory requirements. But so it works also on the causation aspect in this way. Yes, he's an infectious disease expert. Yes, they make a big deal of the fact that we're not questioning his qualifications. But he doesn't have the experience. Nowhere in front of you is there any indication that this doctor knows anything about spinal epidural abscesses specifically, or how many he's treated, or how many sterile seromas he's treated, or whether he even knew the statistics for incident of infection after spine surgery. In fact, he admits he didn't know those things. So the fact of the matter is, he may have experience, but not in this field. So, and I also submit that unlike a standard of care expert, where there might not be literature that supports a standard of care opinion, but gosh, based on my experience, I know that this is commonly accepted in the field. When you look at causation evidence, though, isn't that more scientifically based? It's really more based on, can you show the science behind the act that's complained of and the injury for which damages are being sought? And here there is no science that is provable. It's all based on supposition or conjecture. Finally, I do want to point out there are some things in their brief that simply just aren't right, and I want to alert you of those. There's a suggestion that somehow an MRI diagnosed this infection. You'll see in the record, MRIs don't diagnose infection. It did diagnose that there was a seroma or fluid in the spinal canal, but not infection. Second, it's represented several times that there were a number of physicians that diagnosed this as an infection, but ignoring the fact that, number one, it was a presumed diagnosis, that they have to proceed with going forward and treating, because if they're wrong, the reaction is, the results can be disastrous. So, and also, at no time was the crosslink ever identified as a source of infection. Never. When they took it out, they didn't see a lot of pus or anything like that. There was nothing in the record to suggest crosslink was the problem or there was actually even an infection. On both of those grounds, they failed their burden of proof, and therefore, the trial court correctly excluded that from the jury's consideration. Thank you very much.
Thank you.
I think I just heard a closing argument. I think overarching our position is Mr. Cummings is free to make that everything he said to the jury. But the fact that his expert disagrees with our expert and their opinions are divergent is what virtually every medical malpractice case is about, which gets to the nub. I have a few points I want to make. First, Judge Downey, I don't mean to point at you. I don't want to go on the record of saying what Dr. Ruman said on that testimony. I don't know. Oh. I think he did, but I don't want you to think I was trying to blow something by you there. A lot of what I just heard was attacking foundation, that Dr. Ruman's opinions were not supported by medical treatises, and his qualifications were in a different area. That's the stuff I addressed in my opening brief that they panned me for, because none of it's at issue. This was not decided, and his opinions were not excluded because he didn't qualify as an expert or they weren't sufficiently grounded on his personal experience. I mean, Sandretto and Preston and Bernstein are the three cases I talked about this in both briefs. That whole argument, and I assumed that's why they didn't re-urge it on their answering brief, but here it comes up today. That ship sailed. So to whatever extent they made that by incorporating Medtronic's argument in the trial court, that wasn't raised again on appeal, in addition to it being just flat false. The better stuff, Judge Johnson, is on reply brief, pages 9-12. Where I quoted Bettis' testimony, saying he wasn't gloved up and touched it 1 to 2 times. And then as you read through the brief, obviously I cite the record in there, Dr. Steinke actually admits later that on page 11 of my brief, that it got to an unsterilized Mayo stand. Dr. Steinke's the one that confirmed that. So even if Bettis was trying to get himself out of trouble by saying, yeah, I touched it, but I only touched the outside, how did it get over on to the Mayo stand? He had to move it over there, which was, and the idea, and again, I can make this argument to the jury, but the idea that there was nothing untoward here that never happened before, that is just wrong. It violates the standard of care. There was an incident report. Bettis was shooed out of all Banner ERs or ORs permanently, and it's a scary thought if salesmen and manufacturers reps can go in and start grabbing stuff that's going to be implanted in people's bodies. This stuff's we're going to be up here again on this kind of stuff. The incident report, I quote on page 7 of the opening brief, Dr. Ruman's declaration, Exhibit 6 to Record on Appeal 278-279. This is, in a nutshell, what our case is about. It explains why he has the opinions he has. It explains why Ruman's was wrong. A lot of the stuff we've talked about here today, sorry about that. And it, in a nutshell, is what gets us to the jury on this. Okay. And I'm out of time. I'm sorry. Thank you very much.
Thank you. Thank you to both sets of lawyers for your briefing and your argument. We'll take the matter under advisement, and we'll issue a decision in due course. Now we'll recess for a bit.